Rob, would you tell us a little bit about the case today and your experience in the past with similar cases?
Yeah, in fact, this was deja vu because I was here in 1996 with my twin brother, Reverend Paul Schenck. We argued our own case, Schenck versus Pro-Choice Network, in 1996. We got a partial victory in 1997 because what we challenged were floating bubble zones. At that time, there were two kinds of laws and court orders being issued, and that was that it protected not only a fixed zone, as in this case today, but also floating bubble zones, that anyone coming or going from an abortion clinic, or claiming to, they didn't even have to legitimately be going, just claim that they were, had a 30-foot zone that protected them from anybody approaching them with a pro-life idea or pamphlet or even a Bible or a religious tract. So we challenged that. That was successfully struck down in an 8-1 decision. We got an 8-1 victory on part of it. But the court chose to treat the other question of fixed zones at another time. Well, this was the other time, and we just heard the court resoundingly shoot down these fixed no-speech zones where the First Amendment is suspended for 35 feet in any direction of an entrance or an exit to an abortion business. Well, that means essentially you can shut down a whole city block if you want to. The court said that's an extreme violation of the First Amendment, that it is unconstitutional, and in the same act, the same action of the court, they affirmed the very caring, loving, sensitive ministry of sidewalk counselors. And I thought that was just as important as striking down these no-speech zones and reaffirming the First Amendment, especially on a public sidewalk, what the court has historically called a quintessential public forum. The court referred to that today in its opinion. But also affirmed that pro-life people are not violent, caustic, loud, obnoxious, menacing presences. The court said, no, these are very quiet, cordial, caring, deferential, respectful people. That was very important to hear from the Chief Justice of the United States. So today was good for the First Amendment. Today was good for the cause of life, most importantly. It was good for sidewalk counseling, and it was good for me because we only got half a victory way back when. We got the full victory today, thank God.
Excellent. Do you have any comments about the Hobby Lobby case coming up?
Of course, we were waiting, anticipating two cases today, the McCullen case on sidewalk counseling by pro-lifers and the Hobby Lobby case on the religious rights of business owners. Well, now we know that will come out on Monday, so I will be here again in the courtroom, and I have a good sense after being in the courtroom to watch oral argument in cases. I've participated in many cases, filed briefs in many cases, had my own case in front of the court. I've met all the justices personally, talked with them face to face, not about these cases, of course, but about other things. I study their body language, their eye movements, even their postures during cases. I'm going to say we have good reason to believe the Hobby Lobby case will be a good outcome, that it'll be a strong reaffirmation of the religious rights of business owners, whether they choose to incorporate or not. I think that a couple of the justices, Kennedy and Alito in particular, in their questioning during the oral argument, gave some hints that they felt very strongly and very confidently on this. I think we're going to see a victory for the Green family, the Hahn family, the two principal families, and for every business owner family in this country that is motivated by their religious convictions. I don't often predict, and I'm often disappointed, even when I think I know what's going to happen, but this one I feel pretty good about.